Spoliation of evidence is a really interesting area of the law in Florida. So what that means is, a layman's way of thinking of it is what to do when somebody spoiled the evidence. In personal injury and wrongful death cases, a lot of times the evidence may be a video. So for instance, our client goes to a supermarket, maybe they fall and get tremendously hurt. We know that there is a video that caught their fall and the aftermath on a video recording, but lo and behold, we get to trial and that video that would be so helpful for our case is gone. Maybe it's been erased or not preserved or recorded over. There's other types of evidence you can imagine that also get spoiled. Spoliation of evidence is kind of evolving in the state of Florida. I really hope that it continues to, but here's where we're at right now. In certain circuits in Florida, if your attorney or you sends a demand for the preservation of very specific evidence, and thereafter you are able to prove that the tortfeasor or the defendant that you're suing failed to preserve that evidence, then there can be what I like to call a punishment. I don't know that that's really the right word, but in certain circuits in Florida, if you can prove that you asked for it, that it existed at the time, and that sometime after receiving your request to preserve this item, the tortfeasor chose not to, or was negligent in saving it and lost it, or something like that. Then if you get all the way to a jury trial, you can get what I call the punishment is certain jury instructions. In fact, the judge can even tell the jury that they are to assume, or that they can assume, that that video, for instance, showed something that was bad for the defendant, and that's why it's missing. Now, unfortunately, in the Second District Court of Appeals, which involves most of our cases, so like Pinellas County and the surrounding areas, we are not in the District Court of Appeals that necessarily says if you can prove that you asked for it and they got rid of it, you're going to automatically get that jury instruction. It's still definitely something we can argue because it is the case in some parts of Florida. It just kind of depends. It's a case-by-case basis.